Let's look at some of the important acts. The first one is the Representation of Peoples Act. To ensure conduct of elections in free, fair, and impartial manner, the Constitution makers incorporated Part 15, Article 324 to 329 in the Constitution, and empowered Parliament to make laws to regulate the electoral process. In this context, the Parliament has enacted the Representation of Peoples Act 1950 and Representation of Peoples Act 1951. Now, the Representation of People Act of 1950 allows for seat allocation in Lok Sabha and legislative assemblies through direct election, lays down procedures for delimitation of constituencies, provides for allocation of seats in the House of People and in legislative assemblies and legislative council of the states, lays procedure for the preparation of electoral roll and manner of filling seats, lays down the qualification of the voters. Now, the Representation of the People's Act 1951, it regulates the actual conduct of elections and by-elections. It provides administrative machinery for conducting elections. It deals with registration of political parties. It specifies the qualification and disqualifications of memberships of the House. It provides provisions to curb corrupt practices and other offences. It lays down the procedure for settling doubts and disputes arising out of the elections. Now, Section 126 of the RPA 1951 mentions that 48 hours before the polling ends or concludes, displaying of any election matters by televisions or similar apparatus in a constituency is prohibited. 48 hours is the cutoff period, not applicable to print media, news portals, and social media. Section 126A prohibits the conduct of exit polls and dissemination of its result during the period mentioned. Now, Section 8, Subclause 3 mentions that if an MP or MLA is convicted for any other crime and is sent to jail for 2 years or more, he or she will be disqualified for 6 years from the time of release. Now, Section 8, Clause 4 allows convicted MPs, MLAs, MLCs to continue in their post provided they appealed against their conviction sentence in higher court within 3 months. Now, the Supreme Court in July 2013, that is Lily Thomas case, struck down Section 8, Clause 4 of the RPA 1951 and declared it ultra vires and held that disqualification takes place from the date of conviction. Now, Section 29 of RPA 1951, political parties should be enforced to submit audit reports to ECI. Now, political parties are eligible to accept contributions from foreign companies defined under Foreign Contribution Regulation Act of 2010. Now, Right to Information Act of 2005, it says that Right to Information Act was enacted to provide legal rights to information for citizens to secure access to information under the control of public authorities in order to promote transparency and accountability in the working of every public authority. Now, its objective is to empower the citizens to promote transparency and accountability, to contain corruption, and to enhance people's participation in democratic processes. Now, the features are that the Act provides for appointment of Information Commissioner at central and state level. Public authorities have designated some of its officers as Public Information Officer. Now, the time period is in normal course. Information to an applicant is to be supplied within 30 days from the receipt of application by the public authority. If information sought concerns the life or liberty of a person, it shall be supplied within 48 hours. So, in emergency cases, it can be supplied in 48 hours. Otherwise, the time limit provided is 30 days. Now, some of the relevant sections are Section 1, Subclause 2, it extends to the whole of India except for the state of Jammu and Kashmir. Section 2F, Subclause F, information means any material in any form, including records, documents, memos, emails, opinions, advices, press release, circulars, orders, logbooks, contracts, reports, papers, samples, models, data material held in any electronic form, and information relating to any private body which can be accessed by a public authority under any other law for the time being in force. Now, Section 4, suo motu disclosure of information by each public authority. However, such disclosures have remained less than satisfactory. Section 8, Subclause 1 mentions exemptions against furnishing information under RTI. Section 8, Clause 2 provides for disclosure of information exempted under Official Secrets Act of 1923 if larger public interest is served. Now, RTI Amendment Bill 2019, the bill removes this provision and states that the central government will notify the term of office for CIC and ICs. Now, the bill removes these provisions and states that the salaries, allowances, and other terms and condition of service of central and state CIC and ICs will be determined by central government. Now, Consumer Protection Act of 1920 2019. The Consumer Protection Act of 2019 replaced the old Consumer Protection Act of 1986. Now, the objective of the Consumer Protection Act of 2019 is to save the rights of the consumers by establishing authorities for timely and effective administration and settlement of consumers' disputes. Now, the features are to establishment of Central Consumer Protection Authorities (CCPA). CCPA will protect, promote, and enforce the rights of the consumers, regulate cases related to unfair trade practices, misleading advertisements, violations of consumer rights. The CCPA will have the rights to impose a penalty on violators. CCPA will have an investigation wing to inquire and investigate such violations. The CCPA will be headed by the DG. Now, rights of the consumer. The following consumer rights have been defined in the Act, including the right to be protected against marketing of goods and services which are hazardous to life and property, for example, alcohol, to be informed of the quality, quantity, potency, purity, standard, and price of the goods and services, to be assured of the access to a variety of goods or services at competitive prices, and to be able to seek redressals against unfair and restrictive trade practices. Establishment of Consumer Disputes and Redressal Commission at national, state, and district levels. The CDRCs will entertain complaints related to overcharging or deceptive charging, unfair or restrictive trade practices, sales of hazardous goods and services which may be hazardous to life, sale of defective goods and services. Now, the jurisdiction is national CDRC will hear complaints worth more than 10 crore, state CDRC will hear complaint value more than 1 crore but less than 10 crore, and the district CDRCs will entertain complaints when the value of goods or services is up to 1 crore rupees. Now, moving on to the Contempt of Court Act of 1971. The Contempt of Court Act of 1971 outlines the procedure in relation to investigation and punishment for contempt. Now, the elements generally needed to establish a contempt are making of a valid court order, knowledge of order by respondent, ability of the respondent to render compliance, and willful disobedience of the order. The Act divides contempt into civil and criminal contempt. Civil contempt, it is a willful disobedience of any judgment, decree, direction, order, writ, or other processes of a court, or willful breach of an undertaking given to the court. Now, criminal contempt is any publication which may result in scandalizing the court by lowering its authority. Scandalizing the court broadly refers to statements or publications which have the effect of undermining public confidence in the judiciary, interference in the due course of a judicial proceeding, obstruction in the administration of justice. However, innocent publications, distributions of some matter, fair and reasonable criticism of judicial acts, and comments on the administrative side of the judiciary does not amount to contempt of court. Now, the Contempt of Court Amendment Act of 2006, the Statute of 1971 has been amended by the Contempt of Courts Act 2006 to include the defense of truth under Section 13 of the original legislation. Defense of truth implies that the court must permit justifications by truth as a valid defense if it is satisfied that it is in public interest. Now, FRBM Act of 2003, the Fiscal Responsibility and Budget Management Act of 2003, that is FRBMA, is an Act of Parliament of India to institutionalize financial discipline, reduce India's fiscal deficit, improve macroeconomic management and overall management of public funds by moving towards a balanced budget. Now, the objectives are to reduction of fiscal deficit and revenue deficit, to achieve intergenerational equity in fiscal management by reducing the debt burden of future generations, achieving long-term macroeconomic stability, better coordination between fiscal and monetary policy, transparency in fiscal operations of the government. Major provisions of FRBM Act of 2003 includes that the FRBM rule sets a target reduction of financial deficit to 3% of the GDP by 2008 and 2009. Revenue deficit has to be reduced by 0.5% of the GDP per year, with complete elimination by 2008 to 2009. Reduction of public debt. Now, the measures to reduce the fiscal deficit and revenue deficit so as to eliminate revenue deficit by 2008 and 2009. The government shall end its borrowing from RBI except for temporary advances, that is ways and means advance. The revenue deficit and fiscal deficit may exceed the target specified in rules on grounds of national security, calamity, or other exceptional grounds to be specified by the central government. Now, the amendments to the FRBM Act are Fiscal Responsibility and Budget Management Act 2003 was amended in 2012 that mandated the central government to lay before the Houses of Parliament macroeconomic framework statement, medium-term fiscal policy statement, and fiscal policy strategy statement along with annual financial statement and demand for grants. Now, the N.K. Singh committee that was set up in 2016 to review the FRBM Act recommended that the government must target a fiscal deficit of 3% of the GDP in the years up to March 31, 2020, subsequently cut it to 2.8% in 2020-21 and to 2.5% by 2023.